Why is Warren discussing what education was like, what public education was like back in the 1860s? It's 1954. He's deciding whether, in 1954, schools across the country should be forcibly desegregated. That's the question. Why is this here? Today, we're talking about one of the most famous landmark cases in U.S. Supreme Court history, the 1954 ruling Brown v. Board of Ed of Topeka, Kansas. This was a unanimous 9-0 Supreme Court decision in 1954, where the Supreme Court overturned its previous precedent in Plessy v. Ferguson, which is a court case that we discussed in this course. Plessy v. Ferguson, you'll remember, is the case that had to do with Louisiana train cars, segregated train cars in Louisiana after the Civil War. It enshrined the policy of separate but equal. So what this case, Brown v. Board of Ed, is about is whether or not the segregation of public schools, and it's specifically about public schools, not all schools. It doesn't include private schools. It's whether or not the segregation, the racial segregation of public schools, violates the 14th Amendment. Because the 14th Amendment provides for or protects the citizens' right to equal protection under the law. What that basically means is that the state or the government has to treat people equally. The state cannot, for example, prosecute one race more vigorously when members of that race are accused of a crime, but prosecute members of another race less vigorously when members of that race are accused of a crime. And so the question is whether or not segregating schools, the mere fact that public schools are segregated by race, whether that fact constitutes an unequal treatment of citizens by the government. That's the question. If the answer to that question is that merely segregating the schools, even when the facilities are equal in some sense, treats one race worse than it treats another race, then if that's the answer, well then that practice violates the 14th Amendment and is therefore unconstitutional. But if the answer is that segregating races doesn't treat one race better than the other, well then that practice would be considered compatible with the 14th Amendment and it could continue and it would be constitutional. Okay, so there are three big things that happen in this opinion. The majority opinion, which all of the justices signed on to, written by Chief Justice Earl Warren. The first thing that happens, and you might have thought this was bizarre when you read it, is that there's a whole discussion of public education in the 1860s. This is happening in the 1950s. Yet there's this whole discussion of public education in the 1860s. What's with that? Let's see what Chief Justice Warren says. In the South, this is in the 1860s. The movement toward free common schools supported by general taxation had not yet taken hold. It is true that public school education at the time of the amendment in the 1860s had advanced further in the North, but the effect of the amendment on northern states was generally ignored in the congressional debates. Even in the North, the conditions of public education did not approximate those existing today. The curriculum was usually rudimentary. Ungraded schools were common in rural areas, where ungraded, I think here means not divided by age or grade. It doesn't mean that your schoolwork didn't get marked. Anyway, ungraded schools were common in rural areas. The school term was but 3 months a year in many states, and compulsory school attendance was virtually unknown. Here's the question. You read this case for class today or whatever. Why is Warren discussing what education was like, what public education was like back in the 1860s. It's 1954. He's deciding whether, in 1954, schools across the country should be forcibly desegregated. That's the question. Why is this here? We get a hint at what the answer is by noticing all this mention of the amendment. The amendment that's being talked about is the 14th Amendment. The 14th Amendment was passed in the late 1860s. And the question is, well, how does the 14th Amendment apply to public education? The idea that all Americans are entitled to equal protection under the law, does that mean that they can't be racially segregated in public schools, schools provided by the government or by the state? One place that you might think you have to look, and that Warren thinks he has to cover his bases by discussing, is you might have to look at the intentions of the lawmakers who passed the 14th Amendment and figure out what they had in mind when they wrote this amendment and when they voted on it. Because if they intended this amendment to be compatible with segregated public schools, well, then the amendment is compatible with segregated public schools. But if they intended the amendment to be incompatible with segregated public schools, well, then the amendment is incompatible with segregated public schools. This discussion of education in the 1860s goes toward or points to or is part of the discussion of the intentions of the legislators in Congress. But how? Well, here's the main way. Because public education basically didn't exist at the time, the legislators had no intentions as to how the 14th Amendment was going to apply to public schools, because there weren't any public schools, or they just didn't think about the possibility of public schools as they exist now, right? Public schools may, in some parts of the country, have existed in some sense, right? But nothing like the way that public schools exist today. And so what Warren is doing is he's clearing the ground in the early parts of this opinion so that he can ignore the intentions of the legislators. He can say, look, I get to decide this case without worrying anymore about what these legislators who passed this law back in the 1860s, right, what they had in mind. I don't have to worry about that because there's nothing that they had in mind as regards how this amendment would apply to public schools, because there were no public schools, and so they weren't thinking about public schools at all. So Warren feels the need at the beginning of this case to address this potential objection to what will be a very controversial Supreme Court decision. So he's clearing the way in the early parts of this opinion. Then, in the next sort of big section, the second big section of this opinion, he's dealing with another potential concern, clearing the way in another fashion. And that's this. He wants to make it clear that the Supreme Court is not really going against any of its recent precedent. Sure, they're sort of overturning Plessy V Ferguson, but that was like almost 100 years ago. And he wants to make it clear that the Supreme Court decisions that had been made in the last several decades about segregation in public schools, well, he wasn't really overturning those. They weren't about the same question. So what he does in the sort of second big portion of this opinion is he goes through all of these previous Supreme Court decisions. And he says, well, look, this isn't really about whether separate and equal public schools are compatible with the 14th Amendment. That decision was based on the fact that public schools weren't really equal when they were segregated by race. That is, the sort of tangible characteristics, he says. That is, the quality of the buildings, the amount of books and resources that they had, the training of the teachers, that sort of thing. Those were all unequal. So it really wasn't testing whether this doctrine has any place in public education, right? Whether this doctrine violates the 14th Amendment when applied to public education, right? So he's making sure to say and explain why we're not really going against any of the recent precedent of our own court. That's the second big thing that Warren does in this opinion. And then the third big thing is he gives the opinion, right? He gives the ruling. Here's what he says. Today, education is perhaps the most important function of state and local governments. Such an opportunity, that is the opportunity to get an education, such an opportunity where the state has undertaken to provide it is a right which must be made available to all on equal terms. The thought there is just, education is so incredibly important. It's so incredibly important to the life prospects of any member of American society. It makes such an enormous, profound difference to how well someone's life can and will go that, well, if the government is going to provide this opportunity or this service, then in keeping with the 14th Amendment, it has to be provided to everyone on equal terms. And so the question is, can segregated education do that? Is it possible to separate schools by race, even if the schools are sort of tangibly equal, which maybe they never were. They certainly weren't frequently. Maybe they never were. Anyway, but even if they were equal, is it possible for that segregated education to provide this opportunity, the opportunity to be educated, to everyone on equal terms? And we get the answer. To separate them, here Warren just means black children. To separate them from others of similar age and qualifications solely because of their race generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely to ever be undone. That is, to sort of hearken back to some of the language of Plessy V Ferguson, what Warren is saying in this sentence is, look, merely segregating the races, even if the facilities are equal, labels one race with a badge of inferiority. And that badge of inferiority is detrimental. And then, this is maybe the most famous two sentences of the opinion, we conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. The idea is that, well, the mere fact of separating school children by race treats them unequally and therefore violates the 14th Amendment and is therefore incompatible with the Constitution and is therefore struck down. There are a lot more interesting philosophical questions to discuss about this case, but I just sort of want to return to the thing that we always return to when discussing one of these court cases, which is, why are we discussing it specifically in this course and maybe specifically at this time in this course? Right? One reason that we're discussing it, if I'm being totally honest, is that it's just a famous, landmark, important case, and you should know about it. That's part of getting a college education. And I was gonna shoehorn it in somewhere if I had to. I wanted to read this case. I wanted you to have read this case. But also, we just read, you may remember, Chapter 5 of The Concept of Law by H.L.A. Hart, right? And in that chapter, Hart introduces the idea of secondary rules. And he says that secondary rules are essential to the existence of a legal system. You need secondary rules if your system of rules is ever going to count as a legal system. Well, one thing is that this case is all about a secondary rule, namely the 14th Amendment. It's a rule about rules. It's not a first-order rule. The 14th Amendment says what the rule-making bodies can and can't make rules about, what they can and can't do. So it's a rule about rules. It's not a rule about ordinary behavior. It's not prohibiting jaywalking or murder or something like that, or requiring citizens to pay taxes. So it's about a secondary rule. Some of the most important fundamental cases, maybe most of them, are about what Hart would call secondary rules. There's that. Then there's also all of the rules that I want you to notice that Warren, Justice Warren, right, Chief Justice Warren, right, seems to be worried about when he's writing, right? So he spent all of this time stressing about public schools in the 1860s. Well, he did that because he was trying to cover his bases. He knew that this was going to be a very controversial ruling by the Supreme Court. But we can only make sense of the fact that he felt like he needed to cover his bases if there was some rule operating in the background that he never states in the opinion. Some rule like, when deciding how an amendment to the Constitution applies to a contemporary practice, you have to go back and figure out what the intentions of the lawmakers were, if possible. That's a rule of interpretation, or a principle, maybe, of legal interpretation. There's this question that you should have in mind, which is, well, is that a secondary rule of the legal system? Ronald Dworkin, who we're going to read later, Dworkin is another legal theorist like Hart. Dworkin might suggest that, well, the principles working in the background in this case that Warren feels he needs to follow, well, these principles can't be understood as secondary rules. They're something else. They're principles, he says, and they're different from rules. We'll get onto that later. The other rule or principle that seems to be operating in the background for Warren is that the Supreme Court, when issuing a decision like this, shouldn't go against its own precedent, or shouldn't go against its own precedent too much, right? That seems to be operating in the background, and that's why he spends all of this time discussing these other court cases and saying why they really weren't about the issue of the constitutionality of the doctrine of separate but equal as applied to public education, right? He goes through and says, well, that's not really about the same thing, and this is not really about the same thing. That's because he feels like there's some rule or principle operating in the background, something like, don't go against your own precedent, or try not to go against your own precedent, to the degree that that precedent is recent. We will talk more about this on the discussion board, but that is Brown v. Board of Ed.